I very much appreciate your holding this hearing on this legislation and on this important evolving technology. And I want to thank and commend the gentleman from Utah, Mr. Chaffetz, for introducing the legislation, which I am pleased to co-sponsor. I'd like to start by asking all four of you, and I'll start with the representatives of law enforcement first, in examining practices of state and local law and state and local law enforcement, what has the experience been in those jurisdictions which require a probable cause warrant standard for the attachment of these devices?
I would probably have to defer to Mr. Cashley here on the state and local law enforcement aspect of that nature.
I'm sorry, Congressman, I can't answer that because I'm not aware of other than until I heard about Wichita, I'm not aware of a jurisdiction that does require probable cause for access. Most of the jurisdictions that I'm aware of use a reasonable basis standard.
Mr. Black or Ms. Crump?
Well, we don't collect that information in law enforcement, but I can tell you that a warrant clearly provides a clear message that a private sector company can feel much more confident responding to without running the risk of violating their customers' rights. It is a clear legal standard that a response to that warrant has been established. I think it provides a level of protection for the private sector as well as for the customer and citizen.
I understand. Well, Ms. Crump, maybe you know of some jurisdictions that impose that standard.
Thank you for the question. When we conducted our 32 state survey, we uncovered a small number of jurisdictions that do require a warrant based on probable cause to track even cell phones. So, for example, the County of Hawaii, Wichita, and Lexington, Kentucky all reported to us that they require a warrant based on probable cause. I do not believe that those jurisdictions would willfully put their citizens in danger in order to impose this requirement. I think it is a more reasonable conclusion to believe that they can accommodate legitimate law enforcement interests while also accommodating the warrant requirement, and that is a reason the requirements set out in the GPS Act are reasonable ones.
Although the court concluded that the government's action in Jones was a search, none expressly required that police get a warrant in future GPS tracking cases. The government effectively forfeited that argument. Further, there's no clear indication of the level of suspicion, probable cause, reasonable suspicion, or something less, that is required to attach a GPS unit and monitor the target's movement. So let me ask each of you, what level of suspicion, probable cause, reasonable suspicion, or something less, should be required to attach a GPS unit and monitor a target's movements or monitor a target via a cell phone? Well, we'll start with you, Mr. Ramsey.
The way I understand the question is you're asking for at what level either
asking you
reasonable
to finish the work of the court, that they punt it over to us and help us find the best way to set a standard that protects the privacy rights of individual and in particular innocent citizens. Our bill, as you know, requires probable cause as a standard, but if you're troubled by that, make a case for another standard.
A lot of times these geolocational devices are used as building evidence. It's the building blocks in some of these investigations, working up to a probable cause warrant for an arrest of an individual. So if you start at the building block level, you're actually near the reasonable suspicion level that a crime...
Okay, I'm running out of time, so I'm going to jump over to Ms. Crump, too, and then if we have time, I'll come back to Mr. Casilli.
In our view, the reasonable suspicion requirement is too low. The warrant requirement, the probable cause requirement, is the basic default under our constitutional system when there is a search. Law enforcement often mentions that it would be useful to track GPS to develop probable cause. However, there are a wide range of useful law enforcement techniques that law enforcement is not allowed to conduct without probable cause because they're simply too invasive. It would surely be useful for law enforcement agents to be able to search someone's home without having to get a warrant, but we don't allow that under our system because we recognize that that is a grave intrusion. When you talk about the type of information that's available through GPS tracking, for instance, being able to tell where someone gets medical treatment or whether they're an unfaithful husband or who their friends and associates are, that is similarly sensitive and should be similarly protected.
Thank you, Mr. Chairman.
The gentleman's time is expired.